Hi, everybody. I'm Gwendolyn Sterk of Sterk Family Law, and I have the honor and privilege to have Jim Smith with us today, who's with Fair Credit Attorneys. Hi, Jim. How are you today?
Hi, Gwen. I'm doing well. Thanks for having me.
Good.
Yeah.
Can you tell us a little bit about what it is that you do?
Sure. So generally speaking, a consumer protection attorney. I've been a consumer protection attorney since 2005. And the last 3 years or so, I've spent most of my time litigating on behalf of consumers under the Fair Credit Reporting Act. That's most of my clients are dealing with credit-related errors, identity theft issues, mixed file issues, other errors that are on their credit reports that shouldn't be there.
Got it. Today we want to talk about the topic of what is an authorized user and what does that mean? I'm sure you get this question a lot.
I do. It's a great question. Happy to talk about it for your clients or potential clients. An authorized user, the most common scenario is a credit card application. So we'll keep it to a spouse relationship. So husband has a credit card, opens it up in his name. He then has his wife be an authorized user, not a joint account holder. So the terms of all of these credit card agreements will vary, but the general idea is that in that scenario, the husband is the only one legally responsible for making the payments, but the authorized user or the wife is allowed to use the credit card and incur charges. She's just not responsible to pay them off. But the authorized user, the spouse in this example, the wife, it will report on her credit report. So if the husband stops making payments, there's derogatory lates, there's a charge off, there's a huge balance, things that will negatively impact his credit score will also impact the wife's credit score in a negative way, which can be very unfair because, for example, the husband would have the ability to perhaps file bankruptcy in order to avoid having to pay the debt. The wife would not have that same opportunity because it's not her debt to pay in the first place. So it's sort of a tricky, sort of bizarre situation that lots of people find themselves in, where there's derogatory credit card trade lines on a authorized user's credit report, and they've got no legal obligation to pay it, and they don't have any real way of getting it paid off other than paying it off themselves.
Now, does that information affect the credit score of the authorized user, or does it just appear on the report?
It does impact their score, and it impacts their ability to obtain a loan. So if the credit report's going to report accurately, it'll say it's like a Citibank card. Okay. It'll say Citibank, and it'll have all of the information, all the historical payment data, the balance, the balance due, and it'll have a status there called authorized user. Okay. So a potential lender will know that it's an authorized user account. So you would think, all right, well, it says authorized user. The lender should know that this person's not legally obligated to pay the debt.
Right.
Except lenders don't look at it that way. I was talking with a lender just the other day, and he said if there's a charge-off authorized user account, the mortgage company, the potential mortgage company that they would hire, will treat that as their own debt. So it definitely negatively impacts the person's ability to move forward to obtain credit opportunities, without a doubt.
Yeah. From a divorce perspective, I also want to talk about the fact that just because it's in one spouse's name, the debt, and the other party is the authorized user, just so we're clear, it limits the credit card company from collecting from the husband only. It doesn't mean that the divorce court may not order the wife to contribute part of that payment back, correct?
That's correct. Absolutely.
So,
yeah.
That's a little different, but you always have to keep in mind that the court, like for a family law matter, Citibank, in your example, is not a party to the litigation, so they're not bound to what's occurring in the divorce court.
Yes, 100% correct.
Now,
go ahead. I was going to follow that up with joint account holders. That becomes a potential issue.
Sure. But getting back to this authorized user, do you have to give someone the authority to add you as an authorized user? Or hypothetically, could somebody, let's say you're in a roommate situation, your roommate fill out an application, and let's say they know your personal data and fill it out and make you and name you an authorized user without you signing the application. Does that happen, and can that happen?
That's a great question, and it can happen. the person that sort of has the authority to add you as an authorized user is the account holder. So if Gwen, you were to have a credit card and you added me as an authorized user, that's probably within your rights under the terms of your credit card agreement. And whoever the credit card company is doesn't have to ask my permission. They're not pulling my credit. In fact, most of the credit card agreements will indicate that I'm not responsible for ever paying back anything on the loan or the credit card, even if I'm incurring the debt.
Right. But I mean, isn't that really unfair? I mean, let's say that I added you as a authorized user because I decided that maybe there might be an occasion when you need to assist a client or do something, and I looking at it as a personal expense, but also potential business expense. So I add you, and let's say I go defunct in my business and I end up with a huge write-off. How is that fair to affect your credit in that hypothetical?
Yeah, and it's not fair. The idea is if everything's working perfectly, an authorized user, it could help your credit score. If the account holder is making their payments on time every month and being responsible,
right,
then the authorized user can sort of sit on the coattails of that account holder and everything's okay. But once this starts turning derogatory and there's payments being missed and there's lates and charge-offs and collections and everything, all of those derogatory comments get stuck on the authorized user's credit report. Not all the time, but very often. I see it a lot.
Then the follow-up question to that is, in like manner, if somebody can add you to an account, so let's go back to the husband and wife situation, and the husband added the wife to the account, if they're having marital problems, the husband then would have total control to ban the wife from having ongoing use. They could stop that person from being an authorized user. Do I have that correct?
That's correct. Yes. The important distinction is the account holder has the authority to add and take off. So if you're an authorized user, and so in the hypothetical, the wife is the authorized user, she won't have authority to call up Citibank and say, hey, I'm an authorized user. I don't want to be anymore. Citibank's responsibility, okay, that's fine. Have your husband call and he can have you removed.
Right, but let's say that there's acrimony between husband and wife, and the husband's like, I'm not going to help you out, so I'm not going to do it. What recourse in that event would the wife have?
Not much with Citibank, or if she can't communicate with the husband, not much that way. She'd have to rely upon a relationship with her divorce attorney to help figure out how to handle that on the front end. If it's on the back end, what I would do from the Fair Credit Reporting Act aspect is I would write a dispute letter with the client and have the client send a dispute letter to the Credit Reporting Bureau, so Equifax, Experian, TransUnion, and tell them that I'm just an authorized user. I'm not legally responsible to pay this debt. It's negatively impacting my credit and ability to obtain credit. I want it removed from my credit score because it's misleading potential creditors. And I would send that certified mail on behalf of these folks. And oftentimes it gets removed that way. If it doesn't get removed, I've had very good success filing FCRA lawsuits in order to get them removed. Even though they're technically correct, all the information there's correct. In Illinois, in the Seventh Circuit, there's very good case law that if it's technically accurate but still misleading to a potential creditor, it shouldn't be on your credit report. And it's our position that these authorized user situations fall under that category. That even if it's reporting everything's correct, but the authorized user isn't responsible for making those payments, it shouldn't have a negative impact on potential credit. So it should be removed.
And I suppose the same would be true in our hypothetical where I added you on as an authorized user and you never gave me permission to do that. You could also dispute that. Is that correct?
Correct. Yes. Yep.
This is so confusing. And how do you tell on your credit report if you're listed as an authorized user or as actually somebody who's responsible for the payment of the debt?
If the credit report is reporting accurately, there will be a status box on the, it's called a trade line. So if it's a Citibank card, it'll be, I call it a Citibank trade line. It's basically information about that Citibank account. There'll be a status box and it'll say authorized user in that box. And that should be indicative that you're just an authorized user on that account. You're not an actual obligor.
And if that box isn't checked and it's an account that you didn't authorize somebody to open in your name, but they did it because they had financial information for you and maybe forged your name and the like, what remedies do you have in that event?
Similar, as far as the Fair Credit Reporting Act goes, similar to my example of sending a dispute letter. I would encourage that person to send a certified mail dispute letter to the credit reporting agencies. Include as much information as you can to explain that you have no idea why you're listed as an account holder, because you've never signed anything and you'd like it removed.
Okay, now let's go one step further. People talk about this debt to income ratio when they're getting loans and maybe getting further credit to buy something, et cetera. And, they say it can affect your interest rate and the like. Would these charges, when you're an authorized user only, have an impact on that as well?
Yes, from my discussions with mortgage lenders, they do negatively impact your debt to income ratio.
Wow, so it almost seems like before you even start looking for a house or going out to make a major purchase like a new car, you really should be looking at your credit report first, cleaning it up so that you can get the best rate and the best extension of credit possible.
No question about it. Absolutely. Step one should be take a look at your credit. And most people's credits is going to report correctly, and these little issues aren't going to be there, or they're not that little. But these unique individual issues won't be there. But when they are there, you have to deal with them as soon as possible. Otherwise, they'll create big problems down the road. So you're absolutely right.
And so I think that, people can start on this journey on their own, but they really need to look at it. How would somebody get their credit report to look at it, and how often do you suggest that they do this?
The best way to do it, in my mind right now, is go to annualcreditreport.com. You can access a free credit report once per week from each of the 3 major credit bureaus. So you can get your Equifax report, your Experian report, and your TransUnion report for free once per week. And it's a soft pull, which means it doesn't impact your credit score in any way. If you do hard inquiries, it might drop your score a point or two, but these soft pulls don't impact your score at all. And it allows you to get a true reading of what your credit reports are saying. And as far as frequency, I would check every 6 months or so. If there's no issues, I would check, every 4 to 6 months.
Yeah, and then if you're going to do a major purchase, you should be checking as well, because I think sometimes people get themselves in this situation. They want the car, right? It's there, it's beautiful, it's shiny. They think they got a great deal. They go in, they get the credit, and they say, well, it's going to be maybe an extra 1 or 2 points the percentage of interest, which could be long-term a major impact, but they don't realize it at the time, and they didn't take care of it in advance. How often do you find that to be the case with people?
Very often. That's using the car purchase example is a great one, because when you're there in the room, they have sales tactics where they have you sit there for long periods of time, where your goal is just to get out of there with the car. And they come back and say, all right, good news, you've got decent credit. Your score is whatever it is, 680. And we can sell you this car at just 6.4%. And you think, all right, that sounds pretty good. And then you leave and you don't realize that there's some issue on your credit score, and it should be great credit, and you should be getting an interest rate of 2% or something. You're not given that opportunity to do a detailed review of your credit report when you're asked to sign the dotted line.
Right. And then when you got to look at it, not just a percentage point of what it's going to affect on the monthly. That's one way to look at it is, I'm paying $20 extra a month, and somebody says, well, that's not a big deal. But when you look at it, $20 a month over the life of the loan, then that's a different number as well.
Absolutely. 100%.
And then even magnify that further when you're going out to buy a home or something of that nature.
Yeah, a 30-year mortgage. Yeah, sure. I mean, it could be $100 a month times 360 months. It's a big deal.
And I think the other situation that we see in family law is a lot of these parents who want to add their children as authorized user, or they become joint owners in order to get their child credit, and then they end up in that situation as well. So what warning would you share to people about really considering joint obligation, authorized user before they ever do the credit in the first place?
It's really, you have to be responsible with your credit. And if you're going to start adding authorized users, now you have an obligation to your kids to be responsible with your credit, because if you're not, it's going to show up in their credit reports. So often I see that a lot, where responsible parents do add their kids when they turn 18 or whatever age. They start just to help build some credit, and it's their kind of attempt at doing a good deed. so just you have to be responsible. You have to pay your bills on time if you're going to add an authorized user as a favor, because it might really help increase their credit. But as soon as you miss a payment, as soon as there's one 30-day late, it's going to hurt their credit, and they really had no sort of choice in the matter to make sure it didn't hurt them. On the flip side, if you're going to be an authorized user on somebody's credit card, you should have the understanding that you might operate as sort of a fail-safe mechanism to make sure that the other person's paying on time. Maybe ask to receive, copies of when the bill's due, so you can just double check, like, hey, Dad, did you pay that bill? Did you pay that bill? Because it really does impact them.
Right, and it also impacts parents when they sign up as a joint obligor on credit cards with their children, and then the children don't pay it. They expect their kids to be responsible. So there's just many different scenarios that I've seen this kind of play out, and it becomes a real challenge to people.
Absolutely, yeah. The co-signer with a car is a big one. That a 17-year-old, 18-year-old doesn't have the credit to buy their own car. The parents co-sign, but the child is responsible for making the payments. That's the kind of the relationship that the parent and the child had. The child doesn't, and so then that brings down the parent's credit score, because the missed payments are also their fault because they're a co-signer.
Well, a lot of different opportunities and a lot of things to think about, and really, I think at the bottom line of the conversation is you need to know the distinction between authorized user or an obligor on a credit card, and you also need to run your report on a regular basis to make sure you understand what's out there. So Jim, can you share with people, you indicated that you could assist people perhaps in writing a letter and putting a demand on a credit card, or ultimately filing an action under the Fair Credit Reporting Act if that becomes appropriate. So how would someone reach out to you to be able to go to that next step if that's a necessary instance in their particular circumstance?
Sure. Well, there's three ways. The first way is you can go to our website, www.faircreditattorneys.com, and you can contact me that way. The next way is through email, Jim, Jim, at faircreditattorneys.com. And then you can also call me, which my direct dial is 708-645-8824. Happy to answer any questions people have. And it's all, the consultations are always free. So there's no harm in giving me a buzz or shooting me an email and asking some credit related question. I'm happy to answer them all.
Well, very good. And if you're out there and you have a family law situation, you also want to make sure that you're dealing with this in your divorce documents as well. So proceed with caution, making sure that you're looking at that credit report before, during, and after the divorce as well. So thanks for your time, Jim, today. We really appreciate it. And we hope that this information has been very helpful to a lot of people.
Yeah, thank you, Gwen.